Hi, everyone, and thank you for joining me. My name is Lynn St. Louis, and I am an estate planning and elder law attorney here at ELG Estate Planning. And today, what we are going to be talking about is the top 7 estate planning myths busted. So if you are joining me on Zoom, feel free to include or ask questions in the chat. If you're on Facebook, go ahead and write those in, and those will be put in the chat for me so that I will hopefully answer your questions before we're done with our time today. So let's go ahead and get started. The number 1 estate planning myth, what do you think it is? That having a will avoids probate. So you see this all the time. People say, okay, I have a will. That means there won't be a probate of my estate. And actually, it is the opposite of that. Having a will means that there likely will be a probate of your estate unless your estate planning attorney set your estate plan up differently. So here it gets very confusing. So let me back up a little bit. In estate planning, there are basically what I'll call 2 platforms of estate planning, either a will platform or a revocable living trust platform. In Washington State, for many reasons, we frequently use what's called a will platform or a will type way to set up your estate plan. So what that means is if we are recommending a will to you and we're saying, here is a will, the will becomes effective upon your passing, upon your death, and then the next step to make sure that the will is implemented is there will be a probate. So people, when they're working with an estate planning firm such as ELG Estate Planning, we try to make it very clear that our recommendation for your estate plan will be a will and not a revocable living trust. And you might go, well, why is that? That's really confusing. We will definitely get into the reasons for that. But number 1, top myth is you've got a will, there won't be a probate. Frankly, the opposite is true. If you have a will, there likely will be a probate. So in a minute, I'm going to talk about how you avoid probate and why you might want to avoid probate. But before I get there, what I want to talk about is why would you want to have this will type of estate plan so that there will be a probate? The reason for that is that sometimes it's really important that you have a will which includes certain protections for people who will be inheriting from you. And the only way to get those protections is if you have a will. And if you have a will that's going to include protections, which I'll talk about in a few minutes, then there's going to have to be a probate process. So just off the top of our discussion here, a will typically means that there will be a probate. Myth number two, a revocable living trust avoids a probate. Well, is that true? It's supposed to be true. That's the whole reason that you would have what we call a revocable living trust estate planning platform, is because you do not want to have a probate. On your death, you want things to go without the need for anything to be filed with a court, no probate, and on your death, all your assets go where you want them to go, where your revocable living trust says they should go. That's the beauty of a revocable living trust. In practice, what do we see actually happening is that people will have a revocable living trust, but they don't understand it and they don't know what is required of them to make the revocable living trust work. And candidly, when you meet with your estate planning lawyer, I'm assuming that you're not doing it on your own. If you're doing it on your own, then it is not likely to be successful. So I'm going to assume that you have an attorney you're working with and they've recommended for you a revocable living trust. And you meet with the lawyer and you think you understand it. It made sense. They told you that if you have a revocable living trust, it will avoid probate. And hopefully they took more time and described for you that in order for your revocable living trust to work, you have to fund that trust. By funding that trust, what that means is you need to retitle all of your bank accounts, for example, into the name of the trust. Your investment accounts have to be retitled into the name of the trust. Your life insurance may be in the trust or it may be outside the trust. Your 401k and your IRA, your retirement accounts, cannot be named in your revocable living trust because of restrictions that accompany those types of accounts. So, okay, so here's our first, oh, I'm confused. I thought my trust handled everything. Well, it doesn't handle your 401k. What are you going to do? Your lawyer should explain to you your 401k should pay by way of what's called a beneficiary designation, and it should pay to those people that you want to receive that asset from you. So here's another step. Understanding your revocable living trust is that not all your assets can be in your trust. I haven't mentioned yet your house. If you're doing your own revocable living trust, you also need to be doing your own deed that puts your house from your personal name into the trust name. And a lot of people don't do that. Even if you're working with a lawyer, I've sometimes seen that the lawyer doesn't help with the funding of the trust, and that creates a major problem. Why is that? If the asset is not titled in the name of the trust does not govern that asset. So then what happens on your death? Well, if you have a revocable living trust, you've seen that you also have a will. Sometimes it's called a pour over will. Why is it called that? Because it is intended to capture all the assets you forgot or couldn't put in your trust and pour over those assets into your trust upon your death. How does that work? How does it pour over? That will is actually filed with a court in the county usually the county where you lived in before your death. And the court takes a look at that will and says that looks like a fine will. And your executor is appointed, your personal representative, and there's a probate process, a probate to capture your house so that your executor can then take and deed that house into the name of the trust. So not only did you end up with a trust administration that your successor trustee needed to handle all the work of administering your estate after your death, you also ended up with a probate in addition to that. The whole goal of having the revocable living trust was to avoid probate. But because people don't understand the work that goes with a revocable living trust, and this is more common than not, they don't title all their assets into the name of the trust. And as a result, there will need to be a probate or some probate alternative plus a trust administration. So even though it sounds really good to have a revocable living trust to avoid probate, keep in mind that there is ongoing work that must be done. First of all, you need to understand what you need to do with regard to the trust and how to fund it. And then if you get more assets throughout your life, or you change banks or in different investment accounts, they have to be put into that trust as well. You change, you sell your house, you buy a new house, it needs to be put into the name of the trust. This isn't necessarily difficult. It just is ongoing required maintenance if you have a revocable living trust. So I can tell you that more often than not, and I don't know, nationwide what the statistics are on how often do revocable living trusts end up having to be probated, but in our practice here at ELG Estate Planning, we see it a lot. And from that experience, I can tell you that people simply don't understand their trusts, that when, this is what I would say. If you are working with an attorney to create your revocable living trust, take time and ask them questions. Ask them, will you be giving me guidance? They probably won't go to the bank with you, the lawyer, but they should do a deed on your house to put it into the trust. And then ask them, can I come back and talk with you? And are you going to charge me every time I talk with you? Every lawyer is going to have a different answer. But what you want to know is that you have a relationship with that attorney so that whenever you have questions about whatever your estate plan is, a will-based platform or a trust-based platform, that you can go see them. They will be there for you, because the only way any estate plan works is if you understand it and you have the support of your attorney as the years go by. And whenever something changes in your life, you can go back to that attorney and they'll help you. So that was number 2 myth. Revocable living trusts avoid probate. Yes, they are intended to do so, but frequently, no, they don't. You have a probate plus a trust administration. Number 3. The number 3 myth is that probate is bad and should be avoided at all costs. So I just told you why people have revocable living trusts, because they want to avoid the probate process, because I know we have all heard horror stories about how bad probates are. Well, the reason that we've heard them is because there are a lot of terrible probates out there. Why are there terrible probates out there? Well, probably because there wasn't a good estate plan. Before I get there, let's talk about it. What I'm talking about, like probate, like you should know what I'm talking about. What is a probate? So probate is the legal process that after your death, your will is filed with the court, and who files it? It normally is your personal representative, their attorney. Personal representative is also called an executor. So the person who's supposed to implement your will. Well, how does a will get implemented? It doesn't get implemented until you die and until the court looks at the will and gives an order that probates the will, that says this will is valid, and the person that you have appointed or named under that will is going to be the personal representative. They're given letters testamentary, which is their legal authority to act, and then the personal representative, go do their job. What's their job? Their job is to gather up all your assets, make an inventory of them, pay any creditors, and then distribute your assets according to the terms of your will. What did you say? Where do you want the assets to go? That's the job of the personal representative, and that's what a probate is. So if it's that simple, you might ask me, Lynn, well then why have I heard such horror stories about probates? Well, where is the probate happening? Is the probate happening in Washington or Idaho? In these jurisdictions, and we are licensed in both those jurisdictions, we have what's called a non-intervention probate. That means the court is not involved. The court, yes, signed the order on the probate and issued the letters testamentary, but beyond that, there's really nothing more that the court is involved with unless we request the court to be involved with something. So the personal representative can sell the property, can liquidate assets, can open an estate account, can do everything they need to do, can give notice to creditors so that they make sure that creditors' claims are cut off or valid creditors' claims are paid, so that the estate will be, we'll know what the estate is so it can be distributed without worry. So in Washington and in Idaho, yes, there's statutes. You have to do the things right, but that's what a lawyer is there for, to help you do everything right in a probate. Yes, a probate costs money. Whenever you are dealing with an attorney, if you've had any sorts of interactions with a lawyer, typically they don't work for free. And so, yes, there are fees that will come out of the estate to pay the lawyer for their work. Notice I said their work. So in Washington and in Idaho, the legal fees are going to be dependent upon how much work was involved, and the better the estate plan, the clearer it was, the less confusion, the less the fees will be. Now, I want you to contrast that with other states where probate truly should be avoided. So if I have anybody here from California, they know that in California, definitely a revocable living trust platform is the recommended estate planning route. Why? Because in California, the legal fees on probate aren't based on the amount of work that's been performed, but on the size of the estate. So if you're looking at the size of the estate and a percentage of that goes to the attorney for legal fees for a probate, of course, you are going to want to avoid that type of fee system. So in California, absolutely avoid probates because it's very costly. Washington, Idaho, it isn't. So that's what a probate is. And from that, you're still probably thinking, well, probate doesn't sound like a really good idea to me. I should avoid it anyway, because it sounds like there's going to be legal fees. Well, the question really shouldn't be, should I avoid probate at all costs? But should I avoid probate because there's no benefit to it and there's a better way? What's the better way? California, the better way is a revocable living trust. Just make sure that it's working as it should. Washington, we have different considerations here as to whether probate should be avoided or if probate might be great, might be a really good thing. I'll get to that. Oftentimes when we meet with clients, we suggest that they avoid probate, but we don't do it through a revocable living trust because that's more complicated than it needs to be. Yes, we will have a will and say, here's the will that backs up what you want. But let's say you're a single person, you've got 2 kids, and you want the kids to inherit equally. That's a pretty simple estate plan, right? So how would we set up their estate plan? We'd have their will that says that, but we are going to avoid probate. How are we going to do that? Your bank accounts can pay on death to your beneficiaries. So if you have 2 kids, pay on death equally to the 2 kids. Life insurance, same thing. IRA, 401k, same thing. Your beneficiary designation will say paid to my children in separate but equal accounts. Your retirement funds will pay out. All they need to do is give your death certificate and all of this will happen. Your car, same thing, an affidavit of inheritance. That's all you need. So where might this avoid probate not work? If you have a house. If you have a house, your house will go through probate unless you've done one very important thing, and that's what's called a transfer on death deed. This is something that we can do in Washington. We can't do it in Idaho, but in Washington, we have a deed. It's called a transfer on death deed. You need to sign it during your lifetime, and it can say it goes to 1 beneficiary or 2 beneficiaries. Frankly, when it gets beyond that number, we don't like to do a transfer on death deed, because when you do a transfer on death deed, let's say it goes to your 2 kids. Well, they're going to both be joint owners. So they both have the say-so about what's going to happen with that house. So with a transfer on death deed, the recipients should get along with each other. That's the goal. Even though your will said it's going to go to my 2 kids, your will isn't probated, doesn't get filed with the court, because the transfer on death deed instead directs that asset. So if probate has no benefit, avoid it. But let's say probate has a benefit. This is where I need you to listen to and it's because it's going to be counterintuitive to you. You're going to say, probate has a benefit? Lynn, I have never heard that. Probate has a benefit. Here's how probate has a benefit. Are you in the state of Washington? Do you want to protect assets for your spouse if you're the first to die? Does your spouse possibly have long-term care in their future? Do they have a diagnosis of Parkinson's or Alzheimer's? Or even if they don't, statistically, somebody who is over a certain age, 65 or 70, the likelihood is, the probability is they will need long-term care. For how short or how long, that's a different question, but they will need long-term care, probability-wise. So in the state of Washington, the only way one spouse can protect assets against long-term costs from another spouse for the benefit of another spouse is if they do it through a will. The will has to contain this special kind of trust. It's either called a supplemental needs trust or an asset protection trust. What it is, it's what we call a discretionary trust. That trust has to be in the will. And in the will, with this trust, upon the death of the first spouse, then all assets will go through the will into this trust. You heard me say they'll go through the will into this trust. How did that happen? That happened through a probate. The only way to protect assets for your surviving spouse in Washington against long-term care costs when you're gone is through the probate process. So does that make sense? Let's say the couple, Fred and Sally, had $1 million estate. Their house is worth $500,000 and they have $500,000 in investment in bank accounts. Fred dies first. Sally is the survivor. Fred's half of the estate is $500,000. We can put that $500,000. Sally has Alzheimer's. Sally needs long-term care costs. Sally will not qualify for Medicaid or the state to pay for her care unless that Fred's will has this trust for her. So by having a will with the asset protection trust, we can protect $500,000 for Sally. Sally's the surviving spouse. She has Alzheimer's. She owns the house in her name, and she has $500,000 in this trust that her husband's will created for her. Sally qualifies for Medicaid, for the state to pay for her care, even though she has $500,000 in trust. If you know anything about Medicaid, Medicaid says a single person can only have $2,000 to their name plus a house. Sally's $500,000 isn't considered hers because it's in a trust. So Medicaid doesn't count that $500,000, and the house also is not counted. It's an exempt resource. So through this really powerful estate planning tool, a will with an asset protection trust, you can make sure your spouse will never, ever become impoverished. They will always have that money in trust because that money never has to be spent on long-term care costs. It can be if you want it to pay for a private pay period, for example, but it doesn't have to be spent. Medicaid instead will cover the care costs. And that is a really important estate planning concept that I want to make sure that I share with you. The only way to get that result is if we do a probate. So if I say to you, probate can be a good thing, that's what I mean. Probate is a way to protect assets for your surviving spouse. And the only way we can do it in Washington is a will that goes through probate. So that was myth number 3. Probate is bad and should always be avoided. Oh, one more thing before I go on. I was talking about a surviving spouse having assets protected. It's for any beneficiary. It's not just for your spouse. Let's say that you've got 3 kids and one of them has lifestyle issues, or one of them is facing a divorce, or any myriad of situations you can think of where the person inheriting from you might need asset protection. it can go into this kind of a trust. Let's say that one of your children is disabled or some special needs. Your will can provide for them in the same kind of trust. Any assets they inherit into this type of trust are not considered by the government to be owned by that person, so their benefits can continue uninterrupted. The money in this trust does not interfere. So it's a great way. Probate can be a very good way to protect assets for those who will inherit from you, make sure that those assets do good for them, that their state benefits are not interrupted because the money isn't considered theirs. So what I want to leave you with is that probate can be a really good thing in the right situation. All right. Myth number 4, without a will, the state gets your money, gets your assets. No, the state doesn't necessarily get all your money or assets. So if you are married and you've been married for, a long time, everything you have is community property. And the state law says that if you're the surviving spouse, even if your spouse didn't have a will, you'll receive all that community property. The state does not get it. Now, if you don't have a will, you lost your opportunity to protect assets for your spouse, but at least your spouse gets everything. The state gets nothing. So when you're deciding what happens to somebody's estate when they don't have a will, what you look at is, well, who is in their life? What's their marital status? Like I said, if they're married, their spouse gets all the community property. What's community property? It's everything they accrued and got together. What happens to the separate property? Separate property is treated differently. Separate property, some of it goes to the surviving spouse and some of it will go elsewhere. For example, like children from a prior marriage. So when you are figuring out who gets what, when somebody doesn't have a will, there will be a probate because that's the only way to figure this out. And the money will go according to what the state laws of intestacy say. Laws of intestacy means there's no will. This is a great example. There's no will. Is there going to be a probate? Yes, there's going to be a probate because there has to be a probate to figure out where everything goes. So a probate can happen with a will or without a will. A probate without a will is one of your worst situations you can be in. It's going to be costly and it's going to be very fact-based as to what type of property was it, community or separate, who are the family members, and who gets what. So with a single person, same situation. They don't have a will, who gets what? Well, they're single, so nothing goes to the spouse. Who gets it? Under the laws of intestacy, the kids get it equally. Let's say there were 3 kids and one of them died. So there's only 2 kids now, but the kid that died left children. So it'll go 1/3, 1/3, and then this 1/3 of the deceased child will get divvied up according to how many kids they had. So it might go 1/6, 1/6 if they are 2 of the grandchildren. So the state doesn't get the money. It keeps going down until there's no more kids or grandkids. If there's no kids at all, then the state says, where does the money go? Under the laws of intestacy, it goes up to parents. There's no parents, they're deceased. Where does it go? It goes out to siblings. Same question. Is a sibling alive? How many siblings? Did they leave children? It gets divvied up. Rarely does the state end up getting the money. There has to be nobody in this line of heirs at law who exists to be able to receive. And that's the reason rarely does the state get the money. It happens, but it's not common. Number 5, everybody pays estate and death taxes. No, that's not the case. Frankly, for the majority of people, at least in the state of Washington and the state of Idaho, I can't speak for any other state. So if you're watching this from a state that has an inheritance tax or different estate tax laws, I'm sorry, I'm only focusing in on Washington and Idaho. So If your estate is going to be burdened or subject to an estate tax, well, congratulations. That means you had a good amount of money. In Washington, our estate tax credit exclusion amount right now is $2.193 million. So if you're a single person and you have $4 million and you either don't have a will or your will just says, I want it to go to my 2 kids equally, yes, your estate will be paying an estate tax to the state of Washington. If you live in Idaho, same situation, you're single, you've got 4 million, you want it to go to your 2 kids, guess what? Idaho does not have an estate tax, a state estate tax. So there will be no tax imposed on your kids inheriting from you that 4 million, 2 million, and 2 million for each kid. So why do so many people think that there is an estate tax burden for, the 99%? There isn't. There isn't, at least not in Washington and Idaho. Now, in Washington, as we all know, property values have been going up recently. And, the house that used to be worth, 300 is worth 900 or something. So, people are looking at their estate being valued at a higher level than it surprises them. So there are a lot of good tools that we have to make sure that the state of Washington gets nothing. I'll talk about those in a moment. But one thing I do want to back up a little bit, I've been talking about state estate taxes. There is a federal estate tax too. So I said Idaho doesn't have a state tax. No, but the federal law applies. Washington has an estate tax and federal tax law applies. So what's the federal tax level right now? In 2022, it is $12.06 million. So if your estate is worth more than 12.06 million, talk to an estate planning attorney with tax expertise to see what you can do to avoid that federal tax. Let me go back to Washington. Let's say you had a $4 million estate and you want your money to go to the 2 kids, you want it to go outright, they don't even need asset protection. Well, what can you do? Well, if you keep it within your estate until you die, Washington is going to get some of it. If you instead have met with an estate planning lawyer and they say, you know what, you've got about $2 million too much. Did you know you can do a lifetime gift to your kids? You've got $2 million too much. Why don't you give 1 million to this kid now and 1 million to the other kid now? And by doing so, you have reduced your estate level down, so it's under the taxable estate amount. Your kids get that money, and there's no tax imposed on that receipt of that money. So you can do lifetime gifting in the state of Washington to reduce your estate down below the estate tax level of Washington state. Now you might be saying, I thought I can only give away 10 million or 10,000 a year or 15,000. What you're thinking of is the annual exclusion gifting level, which is 16,000 right now, and it goes up, but right now it's 16,000. So you can give $16,000 away to unlimited number of people and not even mention it to the IRS. But if you give away more than that, if you give away 1 million to this child and another million to that child, you have to tell the IRS you did so. Is there a gift tax imposed? No, there's not. But you have to mention it because it counts against your 12.06 million credit exclusion that the federal government gives you. But this lifetime inter vivos gifting is a way to reduce your estate tax if you live in Washington. Now, there's reasons not to do that, a lot of reasons. There's a lot other planning options, like you can create an irrevocable trust, and then the children get the trust or get the money in a trust so that it's protected. There's all sorts of other planning strategies, and I'm not going to complicate it too much today. But what I want you to know is that there are strategies and there are ways to avoid an estate tax. And rarely is an estate tax imposed at the federal level, or I don't know how rare at the state level, but for the majority of people, estate taxes can be avoided. So if your estate is less than $2 million, or if you're married, you have all sorts of other planning options, you're not going to be paying an estate tax to the state of Washington. If it's above 2 million, do talk to your estate planning lawyer, because there's a lot of strategies to avoid paying any estate tax to the state of Washington. All right, so that was myth number 5. Everybody pays estate taxes on death. Not true. If you do, you are in a very good financial situation. Myth number 6, and it kind of ties in with myth number 5. Myth number 6, only wealthy people need estate plans. Well, definitely wealthy people need estate plans, but not only wealthy people. Do you remember when I was talking to you about wills with asset protection so that you can protect money for the surviving spouse if you're the first spouse to pass? You know, let's say you have $1 million estate. Let's say you have a $600,000 estate. Let's say you have a $400,000, a $200,000. It is so important that you protect money for your spouse so that your spouse won't be left impoverished, so that your spouse won't run out of money when you're gone. It's in a way more important for those folks who have, I'll call it modest estate, modest meaning below the 2 million Washington level, to protect money for your spouse, to protect money for your kids, to have an estate plan. Because without having the right estate plan, there is a possibility, a good possibility, depending on the size of the assets and the income and the care, that they are going to go broke. And when they go broke, they'll go on Medicaid and everything will be gone. That doesn't have to happen. And I hope it doesn't happen in your situation. And an elder law attorney who understands Medicaid strategies will have as a part of their estate planning guidance and recommendations to you a way to protect assets for your spouse, for your kids, for your loved ones. I've been talking about what happens when you die. That is not all that an estate plan is. An estate plan encompasses not just either the will or the trust or the transfer on death deeds, etc. It encompasses what I call living documents, which documents I believe are much more important. Your living documents are those legal documents that protect you while you are alive. And those include your durable powers of attorney for finances, your durable power of attorney for health, medical decisions, and thirdly, your healthcare directive that's also called a living will. Why are these documents so important? Well, first of all, none of us ever want to think about the fact that we won't be in charge of our own life, of our own affairs. But reality is, and I'm sure many of you have experienced this in your family or with your loved ones, that there is cognitive decline that often happens with aging, be it, Alzheimer's or some other form of dementia. There are accidents that happen to much younger people, car accidents, there's strokes. This is probably why people, and thank you for being here and listening, this is probably why people don't even want to talk about it, is that when you're thinking about an estate plan, you're thinking about some really serious things. Like, what happens if I become incapacitated? Who's going to take care? I'm not dead, but I'm incapacitated. Who's going to manage my affairs? Who's going to pay the bills? Who's going to talk to my doctors when I can't talk to them? The durable powers of attorney, these living documents, are the documents that safeguard your wishes. Through these documents, you appoint someone you trust, who knows you, who will do right by you. And you have appointed them to be what's called your attorney in fact. You often hear it referred to as an agent, like a healthcare agent or a financial agent, or maybe, commonly they're called a POA, power of attorney. That means somebody who has been appointed under your durable power of attorney documents to act on your behalf. Now, if you don't have those documents and if something happens to you that you no longer can manage your own affairs, what happens? The state steps in. The state will appoint a guardian or a conservator to manage your financial affairs, to talk to your doctors. That could be somebody you know. It could be your spouse, for example. If you lose capacity, your spouse has no legal right to manage your financial affairs. That's a huge surprise for people. If your spouse loses capacity, maybe the court will appoint you as the guardian, but everything you do is subject to the court saying, yes, you can do it, or no, you can't. You have to give financial reports every year, a personal care plan every year. If you want to sell your house, your name's on it, so is your spouse. Your spouse is incapacitated. The court has to tell you, you legally can sell your own house. This comes as a really unpleasant surprise for people. So how do you avoid that situation? How do you avoid court being involved in managing your business through a guardian, or at least the oversight of the guardian and all the costs that come with that? Durable powers of attorney. That's what you need to do. These durable powers of attorney ensure that if something happens to you, if something happens to your spouse, that, if it's your spouse will likely give you the authority so that you can manage affairs. If it's not the spouse, oftentimes it's the adult children. If it's not the adult children, it could be a number of people. As long as you trust and you appoint them, they'll make sure that your affairs are managed, and that the court has nothing to do with your business, with your life. That's why it's so important and so often overlooked. Here at ELG Estate Planning at Elder Law Group, we do Medicaid asset preservation strategies. What that is that we help people preserve assets when they apply for Medicaid so they don't have to spend down all their money. If we don't have a good durable power of attorney in place, our hands are tied. There are great strategies that exist that we would love to put into place to protect money, but we can't do it. Why? Usually it's because the durable power of attorney was drafted either a long time ago or by somebody who did it online for themselves, or oftentimes it's by an estate planning lawyer. So the person did the right thing. They went to an estate planning lawyer, but they didn't go to one that had elder law expertise. And without the elder law expertise, all of these types of authority that we want to see in a financial power of attorney simply aren't there, because the estate planning lawyer, not knowing Medicaid, not knowing elder law, didn't realize it should be included. So it's really important that you seek out the services of an estate planning lawyer, but one who has the elder law experience to make sure that you've got the right durable powers of attorney, the right estate plan. The one other living document I haven't spent much time talking about is what's called a living will or a healthcare directive. That is the document where you put in writing that if the doctor says that you are at end of life in a permanent vegetative condition or terminal condition, and medical treatment is not going to help you recover, but it may prolong your life, it's up to you to say, do you want that? Do you want heroic measures, or would you rather be allowed to pass peacefully without pain? Whatever your decision is, it will be right for you. Put it in writing. And having that in writing also helps alleviate the guilt that your healthcare agent might have if they are actually saying to the doctor, let's go ahead and remove those machines that are keeping my loved one alive, because that's not what they want. So those are the three documents: durable power of attorney for finance, durable power of attorney for healthcare, and your healthcare directive, also known as a living will. Now, Sometimes the durable powers of attorney are combined into one document. That's fine. There's no problem with that, as long as they have the necessary authority in that you grant to your agent. Here at ELG Estate Planning, we do have those as separate documents. The reason for that, there's multiple reasons. Sometimes people want a different decision maker for finances and a different decision maker for their health. Okay, much easier to put it in a separate document. Another reason is that ours are quite comprehensive, and that means that they're lengthy. And for those reasons, we want to have those separate. And another reason is, you know what, your banker doesn't need to see what you put in your healthcare power of attorney, and your doctor doesn't need to see what you put in your financial power of attorney. So we draft ours separately, but that doesn't mean that a combined power of attorney document isn't okay. It certainly can be. So what I hope that you've gleaned from what I just shared with you is that estate planning isn't just for wealthy people. It's for people. If you're an adult, if you're over the age of 18, you need an estate plan. Now, do you need a will if you're 18? Maybe not. If you're 25 and you have a minor child, do you need a will? Absolutely you do. Why? Because you have a minor child, and in your will, you're going to nominate who that guardian of your child will be if you die. And if you're 18 or if you're 25, you could be in an accident and you're not killed, but you are incapacitated. And if you don't want the court to manage your affairs through a guardian, then you'll need a durable power of attorney where you've appointed somebody you trust to do so. So it really isn't about how much money you have. Estate planning is a lot about protecting the person, protecting their decision-making, their autonomy, and making sure that the court is not going to have involvement with lifetime decisions, and upon death, that the assets are going to go where they should go, however grand or modest those assets are, and that there's protections in place so that whomever inherits from you has that your money that they inherit will do the most good for those people. And you're the one who knows that best. Nobody else knows that. You know who needs protection in your family and who doesn't. The estate planning lawyer and elder law attorney is there to guide you to that right decision. Myth number 7, there's always tomorrow, so I can do this later. I get my plan in place later. Well, sure, we all believe that there's always tomorrow and that there will be time. If this starts to weigh on you a little bit, if you have in your mind, you know what, I really should be looking to my estate plan, then that's enough to reach out and meet with an estate planning and elder law attorney. Yes, of course, we hope that there's always time and that there's always tomorrow. I tell my clients, I don't have a crystal ball. I don't know what tomorrow may bring. I'm a very optimistic and hopeful person, but I'm also an estate planning lawyer. What does that mean? I know things happen, bad things happen all the time to good people. Don't let yourself be that person where you leave, your family, your loved ones, your assets with no direction, with a probate that is a very difficult one, or with a court-ordered guardianship because you become incapacitated and now the court is appointing a guardian for you. Estate planning is one of those things that it's tough, because what does it require? You have to accept your mortality. I had one client say, I just signed my will and I'm not dead yet. This is great. It's like, yes, you've signed your will and now just don't worry about it anymore. It's taken care of. You've got a good estate plan. Go live your best life. Stop worrying. Did you do something wrong or there's something more to do? Go to somebody that will give you that confidence that you've got the right estate plan in place for you. You don't need to worry about it anymore. But do take steps now. Take steps when it's on your mind. Don't wait until it's too late, because sometimes it is too late, and that's not what you want to leave for your legacy for your family. Okay, This is, you didn't know this, but bonus myth number 8. Once you have a plan in place, you're done. In a way, when you have a plan in place, you don't need to worry about it anymore. But life goes on. What does that mean? Well, there's somebody's health has declined, or maybe there's been a divorce in the family, or maybe there's another birth, or life happens and it goes on. Reach out to your estate planning lawyer and your elder law attorney if something in your life has changed that's momentous. And again, if you have a revocable living trust, reach out more often, because those need management. What's a general rule? Review your estate plan with your attorney if it's been 5 years, or if something significant in your life has changed. But the good thing about having your estate plan in place is you no longer have to worry, what do I need to do? You've done what you need to have done, to have accomplished. Don't worry about it. But yeah, revisit it every 5 years, or whenever anything has happened in your life that's a big change. That is all I have. I just got a message that people cannot hear me. Can you? Oh, I know what you're saying. That noise was not something that was bothering other people. Good. Thanks for sharing that with me, Colleen. All right. What questions do we have? And thanks for staying with me. I know we got about 10 more minutes before we all want to sign off. Anybody have any questions in particular that I can answer for them? How late is too late for an estate plan? I love that question. I'm not encouraging procrastination, but what I do want you to know is that, let's say somebody has been diagnosed with Alzheimer's. That's not too late for an estate plan to get it in place. Actually, that's a really good impetus to get it taken care of. The Alzheimer's has progressed. Right, it's getting a little bit more problematic. The Alzheimer's has taken over, and that person no longer has the ability to understand anything. It's too late. This is usually a gradual process between the diagnosis and the too late. As an elder law firm, we often meet with clients with diminished capacity. That doesn't mean it's too late to do an estate plan. We are very skilled in making sure that the person understands what their plan is, but they don't need to know all the complexities about all this. As long as they can comprehend and they can let me know, I understand that by signing this will, I've taken care of my wife, and then my kids get the money, and that it's going to be protected for her. That, and if I see that and I believe and I look in their eyes that they are tracking with me, I will find capacity in that. On the other hand, if they are just repeating one word over and over and they just don't understand, it's too late. So don't you yourselves make that decision without the input of an elder law attorney. And don't believe just because the doctor gave a diagnosis means it's too late. It isn't necessarily too late. When is it too late? Capacity is completely gone, or the death has already occurred. That's too late. I can tell you, we really do not want to be signing estate plans in the hospital. Have we done it? Yeah. Do we want to? No. It's stressful for everybody. When a family is dealing with a loved one's declining health, last thing they need to be worrying about is their legal stuff, the estate plan. That should already be done in advance. Focus on your loved one. It's another reason I don't like the hospital signings, but whether it's too late, a lawyer can help you with that determination. And same sort of question, can someone make a will if they're on their deathbed? There's all sorts of laws on a deathbed declaration. I'm just going to answer it specifically with regard to a will. Yes, they can be on their deathbed and they can do a will. It must meet all the formalities that Washington law requires. Again, I don't recommend it, but it can be done. Here's a question. I am still confused about titling. Who needs to be on things such as bank accounts, annuities, insurance policies, etc.? All right. So question is, which is a great question, because these assets like bank accounts and insurance policies, who's supposed to be on title to them? Well, if it's a life insurance policy, you probably own it. You're the owner, and you're either going to say it pays on death to my kids, or you could say it pays on death to a trust, pays on death to whomever you want it to pay for. That's the beneficiary designation. When it comes to like your bank account or your investment account, and you don't have a revocable living trust, who's supposed to be on title? Depends on how your estate plan is set up. Sometimes usually we tell the client, if you're a single person, just your name on the title, have it pay on death, either to your kids, or if we're going to do a probate because your kids need asset protection, have it be directionless. So only your name is on it, and it's not going to pay directly to somebody. So if it doesn't pay directly to somebody, it goes through your estate, through your will, through the probate, into an asset protection trust. But one of the things that people often get confused about is, like, if you go to a bank and you say, I want my son to be able to write checks, your helpful teller might say, oh, great, let's just put his name on the bank account with you. And they probably just gave you really bad estate planning advice because they put that your kid's name on your account as a joint tenant with right of survivorship, which means not only do they have the authority to write checks when you are alive, they are a joint owner, and on your death, they own the account. You didn't want that. You just wanted them to have authority, but the teller was helpful and it wasn't clear. And now they own one of your assets. And they might say, you know what, other siblings, mom put me on the account because I was her favorite anyway. And so I know her will says it goes to all three of us equally, but I've always been the favorite kid, and that's why mom put me on this account. And then that ends up in litigation and not a good situation. So this is one area of estate planning we often get a lot of questions from clients, is talk to the estate planning lawyer. Now, exactly how am I supposed to set up this account? In your own name is typically what we'd say.